Welcome. My name is Aaron Gott, and you are attending Antitrust versus the Government, Litigating Government-Induced Competition Problems with Quimbee CLE. Again, my name is Aaron Gott. I'm an antitrust lawyer and partner at Bona Law PC, and I've been litigating cases involving governments since I first started my career. This is an advanced CLE course involving complex issues that arise in antitrust litigation. If you haven't already, you should check out our Antitrust 101 CLE, which will give you a solid foundation of antitrust law. So this course is about litigating antitrust cases against state and local governments, which shows the inherent tension between federal supremacy on the one hand and dual federalism on the other. The federal antitrust laws are a longstanding and overriding national policy in favor of competition, and Congress has affirmed and reaffirmed it over and over again. The federal antitrust laws are the supreme law of the land. But, and this is a big but, sometimes it isn't. States have the power to regulate economic activity, and unsurprisingly, they do so sometimes in ways that are anti-competitive. Sometimes they even allow private parties to do anti-competitive things. The courts have generally allowed states to do this, but we're going to talk about the circumstances under which they can and how to litigate those issues. This course is going to cover the most commonly implicated doctrines when there is state involvement in anti-competitive conduct. By the end of this course, participants will learn how government involvement in otherwise actionable anti-competitive conduct, that is, an otherwise meritorious antitrust claim, can affect liability and damages in antitrust litigation. Participants will learn the principles and application of the state action immunity, and participants will learn about related doctrines that arise in antitrust cases involving government conduct. Those include the Local Government Antitrust Act of 1984, the 11th Amendment and sovereign immunity, Ex parte Young, and various abstention doctrines. So I mentioned before that I've been doing this for quite a while. The first antitrust case that I was involved in when I first started my career was a case involving a state licensing board that had acted anti-competitively. Since that time, I've been involved in every Supreme Court case to cover the issue and a good chunk of the U.S. Court of Appeals cases that have dealt with state action immunity and related issues as well. I've litigated a number of state action immunity cases in trial courts and advised lots of other clients on issues surrounding government involvement in anti-competitive conduct and the state action immunity. Even despite all of that, I still find myself learning new things all the time. This is a really deep subject, and our goal today is to just give you a broad, round understanding of the issues that are most likely to arise when you're litigating cases involving the government. So with that, today we're going to try to understand how government involvement can affect the application of the antitrust laws. We're going to cover the state action immunity, and as part of that, we're going to discuss the backdrop of federal antitrust law, the guiding principles that underpin the state action immunity. We're going to talk about the application of the state action immunity. And we're also going to talk about key cases that have decided state action immunity issues. We're also going to talk about a couple of related doctrines that often arise in cases involving government conduct. Those are the Local Government Antitrust Act of 1984, the 11th Amendment, sovereign immunity, and Ex parte Young, and then abstention doctrines as well. So most of this course is about the state action immunity. Well, what is the state action immunity? The state action immunity is a doctrine that provides an affirmative defense from liability to an antitrust claim. If the defendant proves the defense, the defendant is exempt from liability.